where we have a system here of kind of majority exclusive representation. When a union wins the right to represent a group of workers, it has a legal obligation to represent everybody in the bargaining unit. And in the 20 states where, starting back in 1949 and 1950, these state-level right-to-work laws were created. What that means is that you can't negotiate a contract provision with a private sector employer that requires everybody to pay union dues or its equivalent in something called an agency fee for the services and the benefits that the union, as a matter of law, has to provide to everybody, whether they're a union member or not. So you've heard about revolutions over taxation without representation. This is representation without the ability to impose fair taxes, right? The union has certain operating expenses. It has certain day-to-day costs. It has to pay full-time officials like Jim to come out and help people with their workplace problems and negotiate contracts. He has people in his bargaining units, I'm sure, who are getting the benefit of his hard work and the union's work, representational work, but are not paying for it. And, good unions are able through constant internal organizing to keep their levels of dues-paying membership up in open shop situations, whether they're in the private sector and right-to-work states or in the public sector. The federal sector is basically open shop and union membership is voluntary, and that's one of the reasons why the federal unions are relatively speaking, some of them, kind of weak. But if they want to do away with this obligation to represent everybody, whether or not they pay, well, that would be a different legal framework for our labor relations system. But it's really unfair and undermining of unions as institutions with scarce resources that come out of other workers' pockets, nowhere else. We're not operating with foundation grants or public funding, right? And so if only 60% of the people in a Utah private sector union bargaining unit are paying dues, they're carrying the burden of representation for the other 40. And the other 40 are what we call freeloaders. And, at a certain point, the quality of representation suffers, because if you get down below 50%, the union then is really strapped. But, any one of us as union representatives, a non-member comes to us, just been fired. They may not have been paying dues for 20 years, but it is a breach of the union's duty of fair representation to say, sorry, we're not going to file a grievance over your dismissal because you're not a member. And if any union did that, they could be sued or have a labor board charge filed against them. So that's kind of the nub of the burden of representation in states where everybody can't be required to pay their fair share.
I can't tell you how many times I've been told in these shops, why should I join the union? I get everything they get. And they do.
Right. Well, even conservatives, libertarians, can suddenly see the light. One of our least favorite Boston Globe columnists, maybe you were reading him when you were in town, is a fellow named Jeff Jacoby. He's, the in-house right-winger. For years, he refused to pay dues to the CWA Newspaper Guild at both the Boston Herald, where he worked, and then the Boston Globe. And then about 5 or 6 years ago, he was accused of plagiarism in a column. And the paper, the liberal Boston Globe, wanted to fire him. And suddenly, this William F. Buckley, libertarian, conservative, right-to-work fanatic, where did he go? Who did he come running to? The Boston Newspaper Guild. And what did he want? He wanted them to file a grievance. Over what? His, threatened dismissal. And the union got it cut down to a 3-month suspension, and the guy is, spewing his right-wing crap on the editorial page of the Boston Globe today. But this was a union grievance and arbitration victory on behalf of a guy who, for years had balked at paying his fair share of the cost of representing everybody. So the light bulb does go off belatedly, even with some hard-headed anti-union folks. Yes. Anybody who hasn't had a chance? Yes, the brother here.
I was wondering, can the state of Utah really authorize firing, let the employer fire an employee just for the intent to try and organize his workforce?
You mean a public agency?
Yeah, right.
a public employee.
It's
It
private.
sounds like we've had somebody who's had experience with that recently.
I was fired a year ago for trying to organize a meeting.
In a state agency or
Private sector?
private?
Private sector.
Well, was your question about?
Yeah, but private, yeah, I came back from overseas and retired here some time ago, but I was surprised to find that attitude. A lot of my kids and grandkids fear any kind of exposure like that to even signify that they're sympathetic towards organizing. Said, well, they're firing tomorrow, and right this very day, they're all the ones that still have jobs. They got to tiptoe around here now. They're going to let some people go. The first ones are going to be, and the union sympathizers.
Right. Well,
Is this state overrule or supersede federal government's regulations?
no. I mean, the one way that, states have been allowed to undermine federal private sector labor law is the right to work law option that 20 or so states have exercised. I mean, the problem of discriminatory dismissals for union activity is a nationwide one. And the concerted activity, the collective activity in the workplace that we were recommending to the brother here earlier as a way of developing some experience with collective action in a non-union workplace, it's supposed to be legally protected, whether you're doing it in the name of forming a union or just doing it in the name of a group of workers trying to improve their wages, hours, and working conditions or protest some change in them. And as the sister here may have already discovered, the problem is that when you are fired, you believe it's related not to your job performance, but what are supposed to be legally protected rights, and they're exercised in the workplace, and you go to this federal agency, the National Labor Relations Board, and you file a charge. They don't always issue a complaint, and even if they do, it can be a multi-year fight if the employer litigates the case. You have to go to a hearing, and then it's appealed to a board in Washington, and they can even appeal it to a federal court if they want to stall paying back pay or reinstating you, which is the remedy. The Employee Free Choice Act would have made it more costly to employers to fire people under those circumstances. The people would have been eligible for treble damages, 3 times their lost wages. What was your experience, if you wouldn't mind talking about it? You were working with a particular union, or?
We were trying to get CWA. It was a call center.
Oh, yes, the one in Provo?
And we were trying to get CWA, but they fired me before.
And did you go to the NLRB, or?
I was a salaried manager. I had no.
Okay. Well, that's another very big problem, is that the private sector labor law has become riddled with exclusions. There's a lot of people who are classified now as supervisors and managers and independent contractors, and denied what limited protection the law provides, which is for employees, not this broad category of managers, who very often are not high-level managers at all, maybe working foremen or supervisors, and really not have hiring or firing responsibility. I'm not sure how much power you had, but it makes it very hard for frontline supervisors who do sympathize and care for the people they supervise to be at all sympathetic, except very quietly and secretly, because they have even less legal protection than hourly or salaried workers.
Steve, we have to wrap up.
Okay.
Just,
One more. Everybody know about the Labor Notes Conference that's coming up?
just in conclusion, I think we had a lively discussion. I hope people found it informative. One of the things that, like Jobs with Justice, that helps connect us in the labor movement is Labor Notes. I just passed out a complimentary copy. I hope that was okay with you,
Yep.
Steve.
And we have some
And there's an upcoming
conference brochures.
conference in April near Detroit that several of you have probably been to or heard about. Steve and I are both going to be there, and I would encourage anybody that's interested in pursuing these questions further to come to Detroit for the April Labor Notes Conference. We have a tradition in Boston of concluding things with something we call the Solidarity Clap. And even though our numbers are small here today, I would suggest that we wrap up on that note, unless you have another concluding remark. Well, let's all give ourselves a round of applause.